At Zakat Foundation of India, we have been deeply studying the Wakf Amendment Bill 2010, which has since been passed by Lok Sabha and is now pending before a select committee on Waqfs in the Rajya Sabha. We have also had widespread and protracted consultations with various other persons and agencies who have similar interest. To start with, I will tell you 5 good points that have been incorporated in the new bill. 1. The cost of Waqf surveys shall be now borne by the state governments. 2. The state Waqf boards shall be established where there are no such Waqf boards in any state, and that should happen according to the bill within 1 year after the enactment of this bill. Thirdly, no minister can be a member of a Waqf board. 4. Rigorous imprisonment has been provided for the encroachers of the Waqf properties. And 5th, the Waqf tribunal shall now have 3 members instead of 1. However, a deep analysis of the whole issue reveals that vital recommendations of the Sachar Committee as well as the Joint Parliamentary Committee on Waqfs have been ignored while framing the new bill. Here, it would not be out of place for me to reiterate the significance of both. The Sachar Committee was appointed by the Prime Minister to write a report on the social, economic and educational status of the Muslim community of India, and it is supported with more than 350 graphs, charts, all fully documented on the basis of the data provided by government agencies only over the years. And the report has been accepted by the government, and it is being implemented to some extent or the other. As far as the Joint Parliamentary Committee is concerned, I think the whole country is aware, particularly these days, what is the significance of JPC. We know that a particular minister had to lay down his office because only of the fear that the JPC is going to probe into the affairs of his ministry. I will now narrate to you 21 points which we at Zakat Foundation of India have been able to jot down, where the recommendations of either Sachar Committee or the JPC or of both, and in at least 1 or 2 cases, even the instruction of perhaps the cabinet have been ignored while framing the bill. 1. This is regarding the compulsory nature of the carrying out of Waqf surveys rather than the option of doing so. The bill should say, according to the Joint Parliamentary Committee, that it is a must that in every state there should be survey commissioner appointed of the Waqfs, and the Waqf surveys should be done according to the provisions that are there in the bill. But then this compulsion has been taken away in the bill, and it has been made optional for the state governments whether or not to carry out Waqf surveys. Point number 2 is regarding which all cases would be subjected to such surveys, and it clearly says, the Joint Parliamentary Committee has clearly said that all the cases since 15th August 1947, that is our great independence, all such cases since then should be included, should be subjected to the survey. But then this provision has also not been included, much to the displeasure of the Joint Parliamentary Committee. Point number 3 is the effect of the notification of the Waqf Survey Commissioner. The JPC had said that the Waqf Survey Commissioner's notification will be deemed mutation of the transfer of such property, of the property. according to the revenue records and for purposes of determination of the title of the property. But then this recommendation has also not been accepted by the government while framing the bill. And why a recommendation of the Joint Parliamentary Committee is not being accepted, that needs to be explained by the government in detail. This has not been done, not even during the presentation of the bill in Parliament by the Minister of Minority Affairs, nor during any debates thereafter. Point number 4 is that the Structure Committee had recommended that the Central Wakf Council should be headed by a person who of course is to be designated as president as existing, but he should be an independent person. He should not necessarily be ex officio minister of in an ex officio capacity the minister concerned. The Structure Committee had said that the minister does not have time, and in any case it needs to be independently, autonomously handled, and therefore there should be a separate president. But this provision has also not been accepted. The Structure Committee had also made a very important recommendation of pivotal nature, that the Secretary of the Central Wakf Council should have a senior level of himself, which should be attributed to the post. And it had clearly said that the level of the Secretary of the Central Wakf Council should be of Joint Secretary to the Government of India, so that meaningful and effective communication and interaction can be done by him on behalf of the Central Wakf Council, on behalf of the entire Waqfs, vis-a-vis the rest of the government. But as of now, ever since independence, as per any Waqf Act which has been passed in the past, including the existing Waqf Act of 1995, there is no qualification, no level prescribed for the Secretary of the Central Wakf Council. And Structure Committee's this important recommendation has also not been accepted by the government while framing the bill. Next point, number 6, is that at the time of the constitution of the State Wakf Board, there has to be one representative of a Muslim lawyer who is a member of the State Bar Council. However, if there is no such Muslim lawyer who is a member of the State Bar Council available, then in that case, another person who is an expert in law should be appointed, should be nominated by the state government as such member. Yet, while writing this, the bill framers did not write that that particular person should also be a Muslim. So this is an important lacuna. Point number 7 is regarding the official member of the State Wakf Board. One representative of the state bureaucratic machinery is also a member of the State Wakf Board, and the bill says that the level of that person can be Deputy Secretary to the state government. Deputy Secretary to the state government is a low level vis-a-vis the level of the members of the State Wakf Board. So, in the view of the Zakat Foundation of India, the level of this person should be the topmost in the state, that is the Principal Secretary to the state government. And if there is no Principal Secretary to the state government who is a Muslim who is available, so therefore in that case, what can be done is the senior most Muslim officer, whosoever is available in the state, can be appointed. So as a member of the State Wakf Board, the provision can be made.